that line that we draw is what the concept of legal cause is all about. So after we have decided that the defendant's conduct was a factual cause of the plaintiff's harm, we must go to the next step and decide whether it was a legal cause of the plaintiff's harm. And what that really means is we're going to decide whether the law should make that cause pay. We're going to decide whether the law is willing to trace causation to that particular factual cause. All right, let's speak philosophically for a moment about this thing called legal cause. We have to draw a line someplace. We've decided that the defendant was negligent. We've decided that the defendant's negligence was a factual cause of the plaintiff's harm. And now we have to decide whether the law will be willing to trace liability all the way from the defendant's conduct to that harm. Whether we can say that the conduct was not just a cause of harm, but a legal cause of harm. Remember, when we spoke about duty, I made reference to Judge Andrews' dissent in the famous Palsgraf case. Judge Cardozo, who wrote the majority opinion in that case, felt that the concept of duty should be used as a kind of a filter to prevent certain plaintiffs from recovering from certain defendants for certain injuries. And Judge Cardozo talked in terms of foreseeability when he said that. Judge Andrews, in a dissenting opinion, expressed disagreement and said he thought that the law should say that everybody owes a duty to everybody else, but he still thought there should be a filter. He still thought that there should be a way for the court to decide that this defendant should not be liable to this plaintiff for this particular injury that happened in this particular way. And Judge Andrews felt that that filter should be part of the concept of proximate cause. We now use the expression legal cause to talk about the process of drawing that line beyond which the law will not be willing to trace liability. Judge Andrews used a very interesting expression when he talked about how that line should be drawn. He said it should depend on a rough sense of justice combined with a rough sense of expediency. And when you take those two ideas, a rough sense of justice and a rough sense of expediency, and put them together, you realize that there isn't going to be a bright line, that there isn't going to be a hard and fast rule that will allow us to predict in every case what a court is going to do when it comes to that legal cause issue. Instead, each judge, each jurist who determines where to draw that line will have to rely on his or her own rough sense of justice combined with a rough sense of expediency. Of course, courts would be too embarrassed to say we're coming to this conclusion on the basis of our rough sense of justice, and so courts state rules. But remember that the rules are really designed to serve a decision which is based on this rough sense of justice and rough sense of expediency. Actually, the courts have developed dozens of rules, maybe 100 different rules for deciding what conduct is a legal cause of what harm. But the three rules that are used most often, and the three we ought to focus on, can really be stated in just a couple of words each. The first is foreseeability. The courts say if the defendant's conduct was a factual cause of harm, it was a legal cause of whatever harm is a foreseeable result of it. Sometimes courts use the word probable instead of foreseeable, and they say if the defendant's conduct was an actual cause of harm, it was a legal cause of whatever harm was a probable result. The restatement of torts, which courts very often apply in proximate cause problems, says something very interesting. The restatement of torts says if defendant's conduct was an actual cause of harm, it was a legal cause of whatever harm does not appear in retrospect to be highly extraordinary. And I think the critical words there are in retrospect. In other words, the restatement suggests that when we decide whether defendant's conduct was a legal cause of harm, we should take into consideration everything that we now know. We should be looking backwards, and we should be saying, knowing what we now know, is the harm that resulted an extraordinary consequence of the conduct or not? Because if it's not an extraordinary consequence of the conduct was a legal cause of it. And I want to tell you something else the restatement says that I think is very significant. The restatement says, whenever conduct is an actual cause of harm, it is a legal cause of harm unless there is some rule of law saying that it is not. What that really means is that we should start with the supposition that if conduct was an actual cause of harm, it was a legal cause of harm. And then we should look for reasons why a court might come to a contrary conclusion. And we've just stated 3 of those reasons. Conduct is an actual cause of harm, but not a legal cause if the harm was not foreseeable. Conduct is an actual cause of harm, but not a legal cause if the harm was not a probable result of the conduct. Conduct is an actual cause of harm, but not a legal cause of harm if, in retrospect, the harm appears to be a highly extraordinary result of the conduct. Let's just look at a fact pattern and see if we can apply these 3 separate arguments. They seem like 3 separate arguments, but when you think about it, foreseeable really means the same as probable. Foreseeable and probable really mean the same as not extraordinary. So it really is the same argument that's just stated in 3 different ways, and my suggestion would be that if you're going to make this argument, you use only one of those phrases. Talk in terms of foreseeability or probability or of what is not extraordinary, rather than trying to apply all 3. Suppose that I'm driving my car in a negligent manner as I drive it across the railroad tracks, and as a result, I tear up the railroad tracks. The railroad tracks are now torn up. And a train is coming along the tracks about a half an hour later, and the driver of the train is reading a novel instead of looking where he's going, so he doesn't see that the tracks are torn up. His train collides with the torn up railroad tracks, and the driver of that train sustains an injury when the train is derailed. And the driver sues me, and we started out with the assumption that my conduct was negligent. Clearly, my conduct was an actual cause or a factual cause of harm, because if I had not torn up the railroad tracks, the train would not have been derailed. We've been given that the train driver, or the engineer, or whatever they call the driver of a train, sustained injury as a result, and so the only remaining question is whether my conduct was a legal cause of that damage. Let's try the foreseeability argument. The plaintiff says, a railroad train travels on rails. If the rails aren't where they're supposed to be, the train won't be able to maintain its course, and it will have to fall off the rails. So, when Finz's negligent driving damaged the railroad rails, it was inevitable, let alone foreseeable, that a train coming along in the near future would be derailed, and a train is such a heavy thing that when it falls off the tracks, anybody in the train is likely to be hurt. Therefore, the injury to the driver was a foreseeable consequence of Finz's conduct, and Finz's conduct was a legal cause of it. And we can really make the same argument in terms of probability. We can say because the train travels on rails, and because any misshape of the rails will send the train off course, when Finz damaged the rails, it was probable that the train would be derailed and that anyone in the train would be injured. And for those same reasons, we can say that in retrospect, it was not extraordinary that the driver of the train would sustain an injury after Finz's car damaged the rails. Notice that in each of those 3 arguments, I didn't just say Finz's conduct was a legal cause because the result was foreseeable, or because the result was probable, or because the result was not extraordinary. I gave reasons why the result was foreseeable, why the result was probable, why the result was not extraordinary. I gave that because. Remember, that's really the difference between a lawyer and somebody who wishes he or she was a lawyer. Okay, let's take that railroad tracks hypothetical a little bit further. Suppose there was a